Good morning. It is February 7th, 2023. We're here for our regular board meeting. We have a full slate of commissioners. We have our administrator, Mr. Davidson, and the clerk of the board. At this time, I'll call the meeting to order, and please ask you to rise and join me in the pledge. All right, the first item on the agenda is the approval of the meeting minutes from December 13th, December 22nd, 27th, and then the special meeting January 20th. Is there any additions, revisions, or corrections?
None for me.
Okay. Next, we'll move down to the vouchers.
Move for approval of fund expenditures in the total amount of $674,710.11 as presented, and note that it has been reviewed and signed by two representatives of the Auditor's Office and the County Administrator.
Second.
There's been a motion and a second. All in favor, say aye.
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 Aye. Is there a one and only voucher?
No, we have a salary. Move for approval of salary, clearing payroll, and emergency management payroll in the total amount of $1,185,690.06 as presented, and note that it has been reviewed and signed by two representatives of the Auditor's Office.
Second.
Been a motion and a second. All in favor, say aye.
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 Aye. Next, we'll move down to the consent agenda. There are 5 items on the consent agenda.
Move for approval of consent agenda items 1 through 5 as presented.
Second.
There's been a motion and a second for the 5 items on the consent agenda with no discussion. All in favor, say aye.
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 Aye. Next, we'll move down to public comment. Is there anybody in the room or anybody on the phone for public comment?
Nobody on the phone.
And I don't see anybody moving towards the mic, so we'll move on down to the closed record hearing, public hearing, conditional use permit 2022-10.
Updates.
Oh, I went past the updates. Excuse me. Thank you. We're to the Commissioner Administrator updates. Mr. Davidson.
Had several meetings concerning the hospital district number 1 with the ambulance to the Coyote Ridge and also the Palouse Falls State Park issue. We have legislation that appears like, don't want to jinx it, but things look kind of favorable in light of that, so I was really kind of pleased about how that seems to be moving along. I had a meeting this week with the treasurer and some of her staff concerning tax title properties. They're making good roads in getting that done. They are identifying different properties, and we'll be bringing those to the board very, very soon for you to take action on. Had a meeting this Friday with Simmons and Shirley with my office, the city manager of Pasco, Adam Lincoln, our legal counsel, and Chairman Didier, and one of our vendors out at TRAC about contract relationship meeting, we'll call it, and I think it came out fairly favorable. So that was good. It was a long meeting, and it went so long that I was not able to attend, even though I put in a RSVP to it. I was not able to attend the sheriff's award banquet, which I regretted, but I did want to make note that I got this good report from the sheriff, and I just want to call out that the awards that were given was Patrol Deputy of the Year, Carson Roski, Support Staff, Lori Schmidt, and Correction Deputy of the Year. Sheriff helped me with this. I think it's Tai Oritz as Correction Deputy of the Year. So they won the 3 awards at this banquet that I wasn't able to attend, but I want to give a shout out to them and the hard work that they're doing with the Sheriff's Office. A couple other things. Want to remind the commissioners that we do have the upcoming meetings continuing to talk about the hospital issue up north with Hospital 1 and the ambulance fees. That's on the 23rd, which is Thursday. And also with the Bi-County meeting on the 21st concerning some of our joint operations. There is an issue concerning that meeting that I will need to talk to you gentlemen in executive session with later. So just a heads up on that.
So on the hospital district, I've had several people calling me, Mr. Davidson. Where are we at on the ARPA funds? An update?
Actually, I just asked Shirley Johns in my office. She is working on solidifying 3 amounts for us that are allocated on the ARPA funds to bring to you gentlemen to solidify. Of all the numerous requests that we have, I think we need to advance 3 of them in a more expedient manner, and she's working on that right now. And those should be coming to you quickly. Those happen to be the request from Public Hospital District number 1, Fire District number 2 for their new fire station, and also we have the Benton Franklin Council of Governments that we're working right now. We have an MOU from them, and I forwarded that to Jen yesterday, so it's kind of, we're beginning stages of formalizing that MOU, and I'll be bringing that. So those 3 amounts will be coming to you very, very shortly.
Okay, thank you. Commissioner Peck?
Most of this past week was spent working legislative issues in Olympia with the state's Legislative Steering Committee under WASAC, State Association of Counties. Has started with a reception with regional legislators, both in the House and the Senate, on Wednesday evening. I had the opportunity to speak with all the legislators from our local districts, as well as surrounding areas, as well as from the west side, various legislators that we needed to help persuade to support county initiatives and bills that would support county needs. Thursday was the Legislative Steering Committee meeting itself, probably about 6 hours in total of going through dozens, if not hundreds of bills that are pending and discussing how they may or may not impact counties and which ones we want to support as opposed to oppose. Had representation, I think, from all 39 counties in the state. Yesterday was a briefing that you gentlemen might have also sat in on, was the weekly WASAC update on the opioid settlement and how those funds are being distributed. And that was the majority of the week spent in Olympia. Thanks.
Commissioner Mullen?
So I had the Greater Columbia Behavioral Health meeting and also discussion there on the opioid abatement settlement. And they are asking for a consensus from all 3 commissioners on who we should have as our representative in the abatement settlement. And it would be my recommendation that we have Shirley Jones represent us, as she is probably the most up-to-date on this entire situation. Just need a consensus from my fellow commissioners on that. Also had the Southwest Aging and Long-Term Care, and also want to point out that the date is drawing closer to the auction for the Wilson House. There will be an open house tomorrow, Wednesday, February 8th, from 1 to 3 to preview the property. If anyone's interested in, I would definitely go by and take a look at it. It's quite a unique house. It's stunning. And I think that bookers are wanting, pre-qualification for buyers. And so if you're interested, I would go take a look at it. Also, I would contact bookerauction.com for a complete listing and the details as far as purchasing the house or bidding on it. So that will be coming up on the 15th is when it'll be the deadline is the house will be selling. So also had the privilege to attend the Franklin County Sheriff's Office Awards Banquet. It was hosted and paid for by the Franklin County Sheriff's Foundation. It was a great event that recognized the outstanding individuals and the group as a whole on the work that they do in protecting our community. It was a great event. We have a lot of outstanding people working in the sheriff's department to do a great job, and they deserve the recognition, so. And then also took part in the WASAC meeting yesterday, again on the opioid settlement that Brad was referring to. And that is it for me this week. Thank you.
Last week, I had the veterans meeting. Due to lack of a quorum, we couldn't really make any, there was no decisions made, but just some discussion about our new VSO. Sat on the meeting with Mr. Davidson about Hospital District 1, Fire District 2, the concerns there, and then also the talking with Joe Schmidt. I also, in turn, called Mark Schessler, the senator, state senator, and told him what was going on. He got a hold of Joe Schmidt and sat in on the hearing. So we've got a couple good men over there working on behalf of our hospital district that is actually occurring quite a few extraordinary costs to the prison up there at Connell and also to the Palouse Falls. So there's a lot of expense there that the taxpayers of Franklin County have to endure due to the fact that we have a state park and a major prison. Meeting at HAPO, for HAPO with Mr. Davidson. Again, we went really late, couldn't get over to the sheriff's, but want to congratulate all those recipients and the whole force for the great job they do for Franklin County, and the sheriff as he is the leader of that group, and he's doing a fantastic job. So just want to say congratulations. That's the end of my report, and with that, we'll move down to the conditional use permit 2022-10, expansion of the City of Pasco process water reuse facility. And at this time, I will open the closed record hearing.
Thank you, Chair. As mentioned, this is a request by the City of Pasco through RH2 Engineering to implement Phase 2 of their three-phase expansion of the processing plant. This plant does not process like raw sewage. What it does is it processes processed water that was used for either primarily for processing food. So it's the runoff from that process is, so they call it gray water in a lot of places. It's not like it's not what comes out of your bathroom. This is all agricultural or agricultural production waters. So that's what this facility is. They're doing quite a bit out there. We'll get into some of that as the presentation. At this point in time, there's no address assigned to the site. It's parcel number 113090058. It's a little bit odd in that this parcel is actually split. There's a north-south with the existing facility sitting on a parcel right in between. It's not real important. It's just a oddity you might see on the map here. So zoning's AP20. The comp plan designation is agricultural, and the entire property size is 164.68 acres. It's located east of U.S. Highway 395, north of East Foster Wells Road, and west of Blasdell Road. So, as mentioned, it's a three-phase project, and this is for Phase 2, and it's the provision of additional winter storage through proposed lagoons on city-owned and reclamation-owned parcels, and establishes a construction site for future pre-treatment. Of the entire site, approximately 70 acres of the north half of the property with additional expansion onto the south half at a future date. The site plan submitted showed the location of 6 lagoon ponds located to the north and south of the existing facility, power and water supply lines, future process water pump station, and a 14-foot wide access road. So, this is the parcel. This is where you're looking to do with future expansion down here as needed in the future. That would come to us. This is the application for today. So if they seek to expand that to the second half, they'll need to do another CUP because we don't have the details. It'll be an amended CUP most likely. It's a shot of the property. On December 15th, notice was sent to technical agencies, property owners with 1 mile, Franklin County Graphic, and due to the fact that there's specific dollars, there's a requirement under this for their funding that we also publish in a Spanish-speaking newspaper, hence we also went with La Voz. Posted the site on or about December 27th and submitted and listed the SEPA and the SEPA registry as 202, 206, 121. Phase 2 of the 3-phase, it'll provide winter storage to the proposed lagoons. Approximately 70 of the 80 total, 70 acres of that top site will be being used with, like I said, on the south half to be used for lagoons at a future date. And we do staff does recommend approval based on the review of the utility goals and policies contained within the Franklin County Comprehensive Plan, along with review of the Franklin County Code. The reason for these is in the winter, the water that comes out of this plant is applied to specific fields. However, that's regulated. The amount that they can do and the total amount of acreage that they can use this water on is controlled by, I believe it's ecology. So the production facilities are pumping out the water, and in the summer and in the growing season, we can spray it or use that water on specified crop circles. But in the winter, there's no need for it, so it needs to be stored somewhere. So that's the purpose of these. This is not the raw water, it's the water that's already gone through the pretreatment. So, Planning Commission recommended findings of fact are that it's in the AP 20 zoning district. It is in accordance with the goals and policies. It will not adversely affect public infrastructure. It will be constructed, maintained, and operated to be in harmony with the existing or intended character. It's an expansion of an existing facility. Location of the height of the structure will not discourage. These are pits, so there's not going to be a lot of height to them. Operation will not be more objectionable to nearby properties by reason of noise, fumes, vibrations, dust, traffic, or flashing lights. And it will not endanger the public health, safety, or general welfare if located where proposed. Best management practice, recommended conditions of approval of best management practices to minimize dust during construction. All work in the basically inadvertent discovery protocols. They did a very extensive archaeological survey of the site already. So their approach, well, first it didn't really find that there was anything there, and then they submitted to AHP and the tribes their proposal, and they concurred that that's the appropriate protocol for the site. An approach permit will be required, and any utility extensions crossing Franklin County roads will be addressed at the time of application. And there's a suggested motion but happy to answer any questions.
Questions, Commissioners?
And we do have folks from the city if you have specific questions for them. As far as specific technical stuff, I'm not going to necessarily know.
Go ahead.
So, Derek, I'm looking at the the resolution, and it says in the final whereas, excuse me, it appears to be in the public use and interest to approve the conditional use permit. My memory's not good enough to tell you if our resolutions in the past sometimes say it is versus it appears. But there's no question from your department standpoint that it's in the public interest. It's more than it appears. It is in the public interest.
It is in the public interest.
Okay.
I apologize for that.
No, I was pretty sure that's what you meant, but future reading, I don't want anybody to have doubts, so let's create a record now. And one of the previous slides you just had up said that they shall comply with requirements and recommendations.
That's my long way of saying the conditions. Sorry.
Well, just asking, you know, if you shall comply with this list, whether you call them requirements or recommendations, really, they're all requirements, not really recommendations.
Correct, yeah.
Okay, well, again, not looking to nitpick your language, I just want it to be in the record that those are requirements, not just recommendations, all of them.
I appreciate that.
Okay, thanks.
So adding all these extra lagoons, that's not going to increase the fumes or the smell from the facility?
Again, I'm going to, well, my understanding is before, what we had, those were sedimentation ponds and things like that, to where the stuff being stored there still had organic material and stuff, whereas that's been since cleaned up. They're using different protocols with regard to that. And the water being stored in these will be already treated. So it's just waiting to be able to be put on the crops when the season arises. So, yeah, it should not be increasing. You just never know with nature what's going to happen, but, you know, there's no reason to expect an increase or change in the odor coming from the site.
Thank you.
So have they got permission from the surrounding farmers to shed this water on their ground? They have to have permission because it is a higher nitrate water, correct?
Honestly, I don't know. For all I know, there's people that want. It's actually ecology says these are the places that you're allowed to apply this, and that's it. So that's kind of where that is.
Because I'm familiar with out here, it used to be Tater Boy, but now it's, what's that?
Lamb Weston.
Lamb Weston, yeah, they're shedding water up Glade Road to numerous farmers, and the farmers actually get compensated for putting that water on the ground, but there is drawbacks. The nitrates can't seal their land.
Right.
And it's tough to open it back up so that it'll perk.
That's my understanding.
But that's what I'm asking. Do they have permission from the surrounding farmers to shed that water?
If I may.
Yes,
I have this
absolutely.
Maria with the city of Pasco. She's the Deputy Public Works Director.
Excellent.
Good morning, Commissioners.
Good morning.
Regarding the nitrogen in the water, our treatment process, which is phase 3, which has come forward in front of you probably a month or two ago, will actually remove nitrogen from this water. And the levels at which we will be applying water will be less than the levels of nitrogen of the water we will be applying will be less than the groundwater that is high in nitrogen. And the way our application is regulated is through the permit with ecology, where we have monitoring wells and we have a crop rotation to ensure that the water we are putting in that has some nitrogen in it, that nitrogen is uptaken by the plant as nutrients, and then whatever percolates and reaches the groundwater is actually clean and prevents pollution. As far as the farms are owned by the city of Pasco. At least currently, the ones that are permitted currently are owned by City of Pasco, and there is a process of leasing those out with established crop rotation. So we choose the crops to ensure the uptake is adequate so that we can do this final treatment and disposal in that land without impact to the groundwater.
How many acres of land does the city of Pasco own out there that they can shed this on, and what do you expect you need for acreage to make this work efficiently?
There are currently 16 circles, and
Okay.
I don't know the acreage, but it is 16 farm circles, and the city is pursuing acquisition of additional circles.
Okay.
There's a study that has been performed where the number was identified, but it's a balance between how much you treat and how much you spread that water, right? You can always combine clean water or cleaner water with the pre-treated water to ensure you're not surpassing that limited nitrogen that is being applied. So we are currently pursuing another 4 circles.
Okay. And these are full circles?
They're full circles.
Yeah. Okay. Well, that's quite a bit of land. Should be sufficient. Thank you.
Thank you.
Is there any other questions, commissioners? Hearing none, no more questioning, I will close the closed record hearing and entertain a motion.
There's a suggested motion on the
Yep.
screen if that's desired.
Move to approve CUP 2022-10, SEPA 2022-29, as presented.
Do we need a resolution number as opposed to a CUP number? I think what Commissioner Mullen read was the file number.
That's,
What does staff prefer? Is there a resolution number?
I think technically, yeah, the resolution number is more precise.
It looks like resolution number 2022-10.
No,
That's-
2023-034.
Yeah.
Okay, I'm looking at the wrong one.
According to the agenda, that's the resolution number.
Yeah, so rather than amend the motion, perhaps Commissioner Mullen, you just rescind that and restate it.
Yes. I'll rescind the motion and move to approve resolution 2023-034 as presented.
Second.
There's been a motion and a second for resolution 2022-034, is that correct?
Yes.
Because it's not filled out here in the, all in favor, say aye.
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 Thank you.
All righty, with that, we'll move down to regular items of business. Mr. Davidson.
First up is the non-bargaining COLA adjustment. This was in front of the board last week and decided to wait a week on it. We're in contract negotiations. I am going to be asking for a closed session a little bit later to allow the HR director to give you an update on the contract negotiations. So if you wanted to move it till after that, I just suggesting, or you can move on it now, whichever.
I had reservations last week about addressing this until we had worked through the process with the unions so as not to get out in front of our own negotiations. But this material has been published in the percentage amounts and the positions are also now public record. So while I still think it would be good for us to get an update on the union negotiations first, any advantage that we may have had in not putting our cards on the table too soon is now behind us. So we could do it either way. I still do think that it's better to have the closed session discussion first.
Commissioner Mullen?
I agree. We should have the closed session information before us
Okay.
first.
We will have the closed session first, so and that takes us down to proposed public works fee schedule packet.
This is revisiting the package we brought to the board earlier. We're charging for approach permits in the county. It is a common practice throughout the counties. We in the past have not done it, but however, we do incur significant costs through the year processing these permits, which essentially are to the benefit of single landowners and not the county road system per se. We've provided some updated financial numbers for the board and request that you give it some consideration.
So currently, we don't charge for these permits at all.
No, we don't.
Okay.
Aren't we required by statute to recover our administrative costs when the principal benefit is to a non-governmental entity, a private landowner?
I believe it is, yes.
So really, this is a recommendation for us to follow the statute.
Yeah, I don't think it is it's explicit as that in statute, but I believe that that does follow statute.
Yeah, I'm trying to recall. I think you might have even mentioned it somewhere in your documentation, but that's okay. I think we agree.
I have a copy of RCW 3675.
Yeah, that's the one. Could you just refresh my memory? Or just, if you would, just go ahead and read it, the
Okay.
part that speaks to our obligation to recover costs, because maybe I'm remembering it wrong.
Basically, this is the last line, and it says, "And all such construction shall be at the expense of the person benefited by the construction." And
Shall be.
Shall be.
I think that means we must. Okay, that's my interpretation. On the proposed public works permit fee schedule that you included, it lists permit type, and then it has permit fees. And I wonder if you could just sort of quickly run through those and distinguish between them, because, for example, I could see how a private approach is pretty clear. It's approach to somebody's private property, but then whether it's paved or graveled, is that on top of the private permit fee? Or-
Well, each of those kinds of approaches have a different inspection requirement and processing, so that's the difference in their fees. And paved approaches are required in our approach policy for roads which attach to a paved road.
Yeah, no, I get all that.
Okay.
I'm looking at your fee schedule, and it says for a private road, it's $300. And then under paved, it says $250, and under gravel, it's $125. So let's just say that it's a paved approach to a public paved road. But it's to private property. So is that $300 for the private property and another $250 for the paved?
No, the private road, I'm sorry, now I
You see where I'm
understand-
going?
I understand
So-
the question now.
so-
No, so what we're talking about is private lanes that have to meet county standard to feed several houses.
Private lanes, not approach, okay.
Yeah,
But that
so
still comes under
We're
approach
talking about
permit.
a private road that needs to meet county standard. And-
Okay, so, interesting, I'd not in all my years heard approach permits being anything other than those short pieces between the public road and the land, but I can see obviously how a lane
Yes.
off of a public road would be just a larger approach.
Yes, and we have several private roads which do connect to county roads.
So would it be accurate then, where it says gravel and where it says paved, that it would be a gravel lane and a paved lane?
More of a driveway or an approach. We probably should have. These are the gravel and the paved on here are the normal approaches that for
Yeah. So
for individual lots out in the county.
This might take a moment, but I'm going to ask you if you would, please, just run through that short list and just give me a quick example of each one.
Okay, top of the list is addresses. We often get requests. These are already accesses that already exist,
But this is to assign an address,
this
mostly
is to
for
assign
emergency
it.
response.
Yeah, and it has least administrative impact to our office, hence the
Okay.
fee. Commercial industrial, we're talking about, processing air plants, storage facilities and things like that where large trucks run.
Now, is that just an approach onto their property, or is that a lane?
It's just an approach generally.
Okay, all right.
And then the two gravel, it would be approach and paved approach, which are your typical driveways.
So those are approaches, not lanes.
Right.
Okay.
And the private road would be what you might consider a lane, or sometimes it's more significant than just a lane. It can
Okay.
be a full-blown road.
Okay. And then the temporary, I understand.
Right.
Okay. You may want to consider just tweaking that language a little bit, simply because I think ideally we write these things for the customer, not
Yes.
for us. And while
Correct.
it makes perfect sense to you, and you've
It-
explained why,
Right.
I'm not sure it would for our customers. So if you'd consider that, I'd appreciate it.
Oh, absolutely. We would
Okay.
be happy to put a more,
I honestly didn't know if gravelled or paved, if there was a distinction there. Let's say it was a private road, and whether it was gravel or paved was going to change, the fee structure, because the engineering and the inspection might be different for those two. So you
That's-
can see how it might be a little confusing.
yes, I
Okay.
get that. Yep.
Thank you.
So on your temporary permit, is that, I'm just going to use an example. If you were farming potatoes and you had to bring trucks in,
Yes, that's primarily what the temporary approach is for. If you're having a field that you do not access regularly, or, you know, it's a one-time, we're farming it, we want to approach at this particular spot, that's a temporary approach, we expect it to go away when operations are done. Or it can be a construction approach if people are building and it's not going to be the final permanent place for the driveway. That would be
so in the
another
past, there's
example.
been no permit process for that.
Oh, pardon, I'm sorry.
In the past, there's been no process for a permit to pull off the county road and into your field.
There has.
There has.
We do ask that they come in and ask for a temporary approach permit. We just haven't charged for it in the past.
So with this process, now if you're going to enter your field, let's say to harvest, are you going to have to get a permit to pull off the road into the field?
If the approach doesn't prior exist in our system. There are some permanent farm approaches out there.
So I guess my question is, if you're going to harvest any of your fields and there's not a access permit in your, or there's no access in your records, that we're going to require all the farmers to get an access permit just to pull off the road and into their field to harvest?
Well, we'd certainly like to see them apply for the approach permit so that we know where they're accessing the roads at. And look for, you know, make sure that we're not having any potential damage from, you know, a large amount of trucks running on and off the road. We want to be able to control the nature of the approach so that we can minimize damage to the road system.
So a few years back, we had some lengthy discussions about borrow ditches, where we pull gravel up off the side of the road, bring it back up onto a gravel road. And I went out and looked at several locations where trucks, not just once or twice, but on a recurring basis, had been accessing the road. And it was shown to me at the time, both on paved and gravel, that those perpendicular approaches on the edge of the shoulder actually do cause a significant amount of damage, especially if it's a big truck and it's on a recurring basis. So you're not really talking about somebody who wants to drive off the road into their field on an occasion to go take care of a problem. You're talking about you're harvesting a field and you're going to be running a number of trucks over the same spot on a recurring basis for the harvest. I could see where that would be appropriate for a permit so that you can ensure that there's not damage or minimize any damage to the roadway.
That's correct. That's is indeed their purpose.
Okay, thanks.
So, I've got some questions for you through your survey here. Grant County's at $50. Does that satisfy their permitting fees?
Let me see if we had that.
$50 across the board, Grant County. Okanogan County, $60 across the board.
No, we have, in the comments, it does not cover their costs.
It does not cover their costs.
No, it does not.
So along those lines, then, would they be willing to work with the taxpayers that are paying for the roads? Because taxes are collected for the roads from the people, correct?
They are, but they are to cover the system in totality. These approaches in particular benefit individual users.
Okay. And Commissioner Peck brought up the fact of our road graders out there reclaiming gravel. And I'd have to refer to Hooper Road where the reclaiming of gravel have damaged the culverts that allowed them to be torn, and then dirt was excavated by those culverts underneath the road from water drain off this, and you've been down there working on it and putting new culverts in. So the reclaiming of the gravel actually causes damage to the culverts if they aren't aware of them and they blade through them.
Yes, that does happen.
Yeah, and we've seen it out there. And honestly, I don't think there's anybody that's out there running a 10-wheeler that will take it through one of those borrow pits, fully loaded.
And they shouldn't.
Well, they can't. It'll break the frame.
Yeah.
I think we're going overboard here on trying to assess costs to the agricultural community, and I'm not in favor of it. I'm in favor of across-the-board fee because we have not charged a fee, and then all of a sudden, we're going to jump up and start charging enormous amounts of money here per field when you got farmers that are farming many fields, and if they have to apply for one at every one of them, and I've never seen a field without an access road. They all got access roads, so,
And it would not impact ones that I believe that already exist.
right,
As I said, some fields do have permanent approaches, and we know about them.
okay.
You know, so this would just be, you know, when there's been a change and you want to move the access and you don't want to keep it permanently in that spot. That's what the temporary approach permits.
And then getting to these fees for access for new property and stuff, I just witnessed out there of a guy that's trying to take care of his mom and dad by letting his sibling and his spouse move into a house that he put in, and it's on a roadway that's paved, but it's not an all-weather roadway, and they had to incur the cost of a $6,000 paved approach. It had to be put in before they were given access, and then the roadway had to be built, which it was all done, and they're moved in. But besides the fees, we're asking them to incur a $6,000 cost for a paved approach off of a non-all-weather roadway. Because if it's an all-weather, I can understand it, because that's got it built up beyond the fog line, and it's a wider road, and those are there for all-weather purposes throughout the winter. They can carry with a load but a non-on-weather road, I don't see us overtaxing our residents for a paved approach when it becomes a paved road. You know, I've heard this, that we're not going to damage it. You got to build that shoulder up, and you got to increase the width of the road, so it's going to be affected.
Yeah, that's true, and it depends on what fiscally is feasible for us to do to improve the road. We have limitations. I would like every road to be all-weather and perfect, but we simply can't do that. I would argue that on the local access roads, which are not all-weather, them being paved, having a paved approach is actually as important as it is on the all-weathers. We have to let these local roads, they need to last a long time on their own without a lot of preservation from us. So we want them to be as damage-free as we can so that we can maintain them as efficiently and cost-effectively as we can. And I would argue that having a paved approach is part of that. But
Well, I'm in favor of an across-the-board fee, but I'm not in favor of these inflated costs for the people that are paying the road taxes to begin with, and they're the ones driving the roads. So I would encourage my fellow commissioners to look at a across-the-board fee instead of these inflated costs.
So, Mr. Erdman, I'm assuming, and correct me if I'm wrong, that you calculated these permit fees based on the amount of time that it takes by staff to review and inspect these.
yes,
You didn't create these numbers out of thin air. You didn't say, gee, it'd be great if we could enhance our budget by this much by inflating these fees.
no, and
These are actually what it costs you to do the work.
yes, and I will point out, even with the main proposed fee schedule that we have, it does not cover our costs. We were still looking at it being approximately $18,000 in the red for this. We're only trying to recuperate some of the amount of staff time, and as you'll see down there, we spend almost $50,000 a year processing approaches.
Yeah, and that's where I was actually headed, is that the statute says that you shall recover these costs. And in fact, you're not even recovering the actual costs, because I saw the numbers, the 49,000 that you just referenced in the read ahead materials, and the fact that it doesn't actually cover these costs. If you were to do a flat rate fee across the board, am I correct that you would be overcharging? Well, if it were $50, it'd be undercharging everybody for your actual cost. But using a flat rate runs the risk of overcharging some and undercharging others. Because
Correct.
not all of these permits take the same amount of effort and work, and therefore not all these permits require the same amount of capture
Correct.
of the cost. So I think the notion of a flat fee is inherently unfair, because it will inevitably, unavoidably overcharge some and undercharge others. And the premise here is that by virtue of the statute, that the amount paid and the person paying it is the person benefiting. So by historical, empirical evidence of what you've incurred in the past, these numbers are below your actual cost, even though the statute says they should be your actual cost. And to have a flat fee for everybody overcharges some and undercharges others. So I think you have fallen at a very appropriate place, which is to minimize the burden on people who have to pay these fees as much as possible, while still recapturing as much as you think you reasonably can in compliance with the state law, and to the benefit, frankly, of the taxpayers, because if you don't have these approaches and the roads are damaged, it's the taxpayers that end up paying for it.
Correct.
So I think you're right where we need to be. It's unfortunate. I wish that nobody had to pay fees for buildings or homes or pools or approaches or anything else, but I think you're in the right spot. And the fact that 20 out of 20 counties that you looked at do this says that they read the statute also. Thanks.
So the temporary permit, temporary access, that change every year? Because temporary to me would be like 3 weeks this year. Well, then next year, at those 3 weeks, I have to go get another temporary permit.
Well, I guess it depends on whether the approach is going to stay where it is.
Well, it's
In
gonna
which
be-
case, I suggest you going for a permanent approach, and it's one and done. But you know, these temporary approaches do have impact. That we see several trucks run through them, you know, for a 3-week period. It's a significant amount of truck traffic, and trucks are the things that damage county roads the most. And all we're trying to accomplish with the temporary approach is try to get it to a standard that is going to minimize the impact of that approach. Now, if you feel that our rate for it is inappropriate, I understand. They do take staff time to process like anything else. And it is the board's prerogative to set the fee. You know, if we allow people to access county roads anytime, anywhere they want, then having an approach policy is useless.
I'm not in disagreement with putting in a permit process for an address or gravelled or paved access, but the temporary access I am not in favor of, because you might be growing potatoes there this year, and you're going to have trucks that are going to come in, and that same field is going to be probably corn or something else the following year. So for these farmers happen to go out and get a temporary permit every time they're going to harvest a field is, I think, is a burden that's being put on them that's over. It's just an extra burden that, you know, they're already paying their property taxes on that property. It's not their intent to destroy the roads, but for them to have to go out and get a permit every time they're going to harvest a field, just one more demand on their time that is very valuable to them. And honestly, I would be very frustrated if I had to go get a permit every time I wanted to harvest a field.
I understand that, as I've stated, these impact the entire county road system. They potentially can damage the road. All we're asking by having temporary approach is let us, make sure that the approach is going to minimize the damage to the road. We understand it takes people's time and effort. The charge for the approach permit, that is a separate issue unto itself, but whether they need to be there or not, I believe they do.
Yeah.
Yeah.
For people that work 15, 16, 17 hours a day, having to go to town and get a permit.
I understand that too. I'm not arguing that it's an impact to them. I realize that. But my job
Sure, no, I understand.
is to protect the road system, and I know, and like I said, sometimes these issues are contentious, and I understand that.
I don't know anybody that likes to have to go get a permit, whether they're building an approach or a house or anything else, and they don't like paying for them. But ultimately, the roads belong to the public, and the taxpayers paid for those roads. And so if there's not an approach and a road is damaged, there's actually statutes that require us to recover the cost of the damage done. And I don't know that anyone's ever really pursued it, but if you're going to drive trucks in and out of a field and damage a public asset paid for by the taxpayers, you're liable for the damage to the road. I suspect that's a lot more costly than getting a permit, which once you've been given that permit, you're pretty much insulated from any sort of claims of damage to the road because it's been signed off by the county and we've said, yes, it's appropriate and it's adequate. If it turns out it's not adequate, then it's not on the farmer.
Correct.
But if they're driving trucks on and off the road and they're damaging public property that we then have to spend taxpayer money to go back and repair, there's a liability there. And I don't think any of us want to even entertain that thought, but I actually think that's what the law requires.
It's
So,
my opinion.
I don't like permits any more than anybody else, but whether we farm or we're engaged in other types of business or building homes or whatever it is, permits are a fact of life to protect the public's interest.
And I just got to argue the fact that your staff may be doing this, but they're paid by the taxpayers.
Yes, they are.
Already collected taxes for the roadways, and they're paid. Now you're saying that they're having to go above and beyond to do these permits,
Well,
which is going to be a created entity here in the county and hit the taxpayers more.
Well, I think it's a difference between all the taxpayers in the county pay to maintain the road system as one, where it's a system that everyone pays into. The private access and the road system in the whole benefits the citizens of the county. Access to the county road benefits the individual landowner.
Craig, I'm the one to ask you the question. Please look at me, not Commissioner
Well,
Peck. You
I'm
keep
just-
looking at Commissioner Peck as if you're looking for approval.
No, sir.
Okay, well, please look at me. I'm the one to ask the question.
Very well.
Okay. So I know these roadways were put in for the public. The public paid for them.
Yes.
And this is an undue justice for our agricultural community to go in there and hit them and make them go get permits. This is not right.
That is your prerogative, sir. And
That is.
and my job is to protect the road system as a whole. And I feel this helps in that.
Okay, thank you.
Not hearing any other comments, I'll take the opportunity to say that I am quite sure that you came into this meeting knowing that this might not be a real popular topic, but I'm not a fan of adding permits or fees on taxpayers any more than anybody else. But I think you've described it nicely, that the road system is paid for by the taxpayers as a whole, and you have a duty not only to create those road systems, but to protect them. And I would argue that if you fail to protect them, you've failed to comply with the statutes, you've failed to comply with your obligations, but you've also failed to recover costs under liability for damage to county roads, which you have an obligation to do as well. So I see it as a choice between holding people accountable when they don't have permits and they damage public assets, and whether you drive onto the side of a road and crumble the asphalt with your trucks, or you drive through a city parking lot and create damage there, either way you've created damage to the public infrastructure for which the individual is liable. So I think the permits, again, inconvenient as they might be, they provide valuable protection for the landowner against any claims of damage to roads, because they've gone through the appropriate approval to get a permit that's signed off by the county. And I just, if we don't have permits for the approaches, then the next discussion, I can assure you, is going to be on the statutes that require recovery for damage to public roadways. It has to be. We can't selectively choose which laws we like, which ones we don't. We have to collectively be responsible for damage that we do individually to public assets. Thank you.
Mr. Davidson.
Craig, just a question on the sheet here. Has these are all Eastern Washington counties, which I probably was very appropriate that you use. And just a question, in your association of the engineers, when you guys meet, the state level and things, has there ever been an attempt? I know that ultimately the boards of every county has to make the decision, and so that's going to lead for variances. But has there ever been an attempt to try to make a more uniform amounts and look at this collectively, what could be suggested to Board of Commissioners that you would all do because when I look at here, there's no consistency on this sheet at all.
No, there's not, and not unusual. And to answer your question, no, not to my knowledge has there been, usually the issues we discuss are I'd say, different from that,
Because you got
Just
fees
isn't
ranging
something has
from
come up yet.
$25 to $437.
Yeah, it's
for
quite a
all.
range.
And I'm assuming that they're all trying to follow the law, so it's it seems like there should be some kind of concerted effort to try to make it a little bit of uniformity as an association. That's what associations do, and the boards could make their own determination, but.
I think it's difficult in one sense to do that because of 39 counties, we all have different standards. And also, inspection standards and things like that to what level we want things to be. And I think it would be difficult to have, I don't think we could be uniform, say, with what King County would charge, because it's just completely different.
I would agree with that. That's why I said.
And with Eastern Washington, too, I mean, we always like to say at those conferences, there's 39 of us, and we have 39 different sets of problems. And, we all have our duly elected legislative authority, and that's who we work for, along with the citizens.
Mr. Erdman, I imagine the cost of employing engineers and inspectors varies pretty widely throughout the state.
I believe it probably does.
And when you look at the cost of reviewing and approving a permit, what you're really paying for is staff time, which varies widely throughout the state.
Yes, it does.
And so I think it's natural and understandable that the rates might vary throughout the state. You've already said that you calculated these, figured the cost for your staff and local costs, what our staff gets paid, and arguably they'll be getting paid more soon because of ever-increasing labor costs. But you've also said that this doesn't even cover 100% of the costs. So that's another reason why they may vary throughout the state. It's the varying degrees of recapture. But I'll remind us all, the statute says the private benefited landowner is supposed to pay the full freight, not a portion of it, with a portion shifted onto the taxpayers who have already paid for the road that we're trying to protect. So,
Well, I appreciate everything that you do, and I'm not in disagreement as far as the permits for, a permanent access to the road, but I guess the temporary just is too gray for me, because some fields you can pull right off onto the road and into your field, but I mean, obviously, if there's a ditch that's going to have to be filled in, well, yeah, I can see a permit process for that. But I would actually like to hear more public comment on it and give the ag community a chance to come in and defend the process and see, because I just don't. For someone to take it too far and say, oh, you need a permit every time you're going to pull off the road into a field.
Well, and part of that process is supposed to examine the need for it. And it may be in those spots that you're speaking about that it's easy to drive off. Perhaps we wouldn't require that. But nonetheless, we need to be aware of potential areas where things are going to be damaged and whether they need to be mitigated. Like I said, I think it is a mistake to, and we're talking about operations here, not just people just driving off the field to check a problem or whatever, or a short, we're talking like a significant, like a potato harvest or some other, where a significant amount of vehicles are coming in and out of a certain spot. And I think if we don't do our due diligence and look at that and say, what kind of impact is this having to the road, we're not doing our job.
Yeah.
So I got one more question for you. The common practice now is the trucks never go out on the road. They have a piler set up and they have the semis line up on the road. Is there going to be a problem with that?
Not that I.
They're actually parking on the road, and I've seen them where they're 30 long on gravel roads. And as the 10-wheelers come up, they sort the potatoes, they go into the trucks take off.
Yes,
Is there going to be a permit for that too?
My mind is a legitimate use of a county road. It's a public road.
But they're blocking the road.
Well, and that, all I can say is that, when other people are trying to use the road, help, be respectful and let them get through. But I don't see any problem with that practice per se.
Well, I agree with Commissioner Mullen, and I think we should have a public hearing on this and let the public come in and speak also, because they're the ones that are going to have to go in and get the permits, and they're the ones that are paying for the roads. And need I remind you that the property owner owns to the center of the road. You only have an easement for that public road.
That's true in most cases, not all.
In most, yes. So I think the public should have their chance to weigh in on this, and we don't have no dialogue here set up for today, but I think this is something that we're not needing to do immediately, and I think we should have a night meeting. This should be one of the topics for our night meeting coming up for the public to come in and weigh in on it.
I would agree. And like I said, I'm not opposed to the permitting fees for a permanent address or a permanent access, but I think the public should have a chance to voice their opinion on this.
I have no issue with that.
Okay.
Okay, so we'll table it until the next night meeting, and we'll have a public comment on it.
Thank you for your time.
Thank you, sir. Mr. Davidson?
Okay, next is HR Director.
Thank you, Mr. Chair. Okay, this topic is about the reclass compensation study that occurred, or is about to occur, sorry. And we have put together a cross-functional team composed of the assessor, the coroner, the clerk, and myself. And we reviewed the proposals, which were a response to the RFP. And so there were 4 respondents. They were Gallagher, which came in at $115,000. We had budgeted $200,000, by the way. HR Compensation Consultants came in at $79,385. Compensation Connections came in at $108,720. And Evergreen Solutions came in at approximately $40,000. After extensive reference checking, the team selected Gallagher to conduct the study. And so we're requesting that you allow us to move forward and contact Gallagher, and I'll give them the award.
Questions? Mr. Davidson, you have something you want? Oh,
No, I thank everybody that worked on the review team with elected officials that worked with.
Appreciate the effort to look at a variety of different vendors and have confidence in the people who made the recommendation, and just happy to see us moving forward and getting this done so we can ensure that we are compensating our employees fairly.
Thank you.
Move for approval of Resolution 2023-041 as presented.
Second.
I've got a motion and a second for Resolution 2023-041. All in favor, say aye.
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 Thank you.
Appreciate it.
So with that, we'll move down to administration office business.
Chairman, this is normally would probably be a consent agenda item. It's the Benton Franklin Fair and Rodeo contract, and it's just a routine, contract that we award every year. I only put it on here for discussion because I want to make note that it was brought to my attention by both county staff and by the fair administration staff that part of this package is for us to have a booth in Building 2, which is one of the prime exhibitor buildings at the fair. And we have a table at that, and that table went unused last year. Solid Waste hadn't used it, which they normally had for many, many years. And so this is just my way of kind of publicly announcing. I did a couple checks, and there doesn't seem to be much interest. I think we should still go ahead and do this because we've been a long-term supporter of the fair. This gets us other things, this contract does, and so we should go ahead and do it. But we do need to actively recruit somebody to occupy our spot that we've actually rent and have historically been in. So I'll reach out to the auditor about possibly voter outreach and maybe some other groups. But this is my attempt to kind of get it out there into the county that we do have this spot and we need to find some use for it. But I still suggest that we go ahead and move forward because this package is much more than just that table, this spot.
And may I suggest that I heard that at the Sportsman Show, Grant County was there with a booth about Visit Grant County. Very appealing. And I think we should probably be thinking about doing that same thing for Franklin County.
We could put together kind of a group that might be able to, from various departments that might be able to help us. I'm familiar with that type of approach. We don't have that type of a department in the county per se, but with this little bit of effort, we got quite a bit of time till the fair. I think we could probably get something organized if that's what the board would like, is for it just be a promotional piece for the county, because we do have visitors that attend from Oregon and various other counties that come to our Benton Franklin Fair. So
We have a host of events here too. The hydroplane races, lots of events that people aren't aware of that we could probably promote. All right. Is that it for your administration? So we're to public comment. Is there anybody on the phone or anybody in the audience for public comment?
you see none? Oh, wait. Oh, I do have. Yes, I'm sorry. There was one. I'm sorry. I said no and there was. Do you have it?
I see. Okay, got it.
Good morning. So I'd like to read a couple minutes of the Commissioners' meeting notes from December 17th, 2019. Goes on from Clint Didier questioned the county's insurance and asked whether or not the rates had dropped. Wanda Hatch calls in and discusses the difficult time of Clint Didier's son and thanks him for being there. Move forward, Victor Scott gave the Commissioner Didier's son well wishes and voiced his concerns on improprieties happening within the legal system. I think that comment is contextually false and should have stated that Victor Scott accused Sheriff Jim Raymond and his Sheriff's Department of 010 failure to take a report upon a criminal report, and he also accused Sean Sant and the Franklin County Prosecutor's Office of Rule 3.3, candor. A lawyer shall not make false statements in a fact of a tribunal or court. See, I think it's very important that you edited what I said and left it void of my context, because it's you put so much detail of everyone else's comments and you leave mine so void. We know that right will be wrong and wrong will be right in the end of the times. Anybody who is of LDS faith or maybe even Christian faith understands right will be wrong and wrong will be right. Last week when I talked about domestic violence, in our department, in our sheriff's department, in our county, people who work for the county and the Franklin County prosecutor's wife gets up and say, oh, don't pay attention to domestic violence, worry about the words that are spoken. Think about it. You're in such a free country that there's a big giant delusion happening here. Let's read one last little bit here. That when they shall answer verily, saying, insomuch that you do unto one of the least of you, you have done unto me. That is what Jesus said. You do it to the least of you, the vulnerable adults, the poor, the women. You're doing it to God. But when a long train of abuses, usurpations, persuading invariably the same object as a design to reduce them under absurd disposition, it is their right and their duty to throw off such government and to provide a new guards for their society and their future security. Such has been the patient and sufferance of those colonies, and such is now the necessity of the constraints. Franklin County has no business being their own county. They can't control themselves. They can't treat the poor and the disabled and women properly behind closed doors. They can't do it on their own. They have no business. No business at all. Brad Peck is the only one with integrity up there. The only one. I can give you a title, but it doesn't make you a teacher. You can have a degree in education, but it does not make you a teacher. I can give you a sheriff's badge, but it does not give you integrity. It does not give you honor. Franklin County commissioners know their sheriff is a criminal, and they stand down and do not act.
Thank you, caller.
It is their duty to act.
Thank you, sir.
We do have another caller.
Hello, you have 3 minutes?
Hi. So I don't know what's going on, but yesterday I did listen in, and there were some accusations about a sheriff beating on some family member. And I listened to a bunch of women talk, and I don't know if it's accurate or correct or anything. I have been looking into it. And I just want to let everyone know that if you are experiencing domestic violence, that it is important for the community to know that there are resources out there. And I was actually quite appalled that none of the women who spoke even addressed the situation, because I am a woman and this is not okay. I just want to let everyone know that there is an outreach office here in Kennewick. It is, the phone number is 509-735-1295. Again, that is 509-735-1295. If you are experiencing anything as horrible as this, please do call us here at 509-735-1295. Thank you.
Thank you. Anybody else for public comment?
Good morning, Michelle Andrews
Franklin County, City of Pasco, both. With regard to this booth that you mentioned, I think it would be helpful to be able to have civil service represented and be able to recruit more people to take our testing and be on our eligibility lists. At this time, we do not have enough names due to a lot of turnover and changes in Franklin County, and due to a lot of pressures from the culture and the negative attitude towards law enforcement. As chairman, I took over rather suddenly, and we've worked very hard, but if there are recruitment dollars that are already available in the budget, I have heard that there were in past meetings, we would like some help with that. Thank you.
Is there anybody else for public comment?
So for the audience, the Franklin County Sheriff's Office currently has no openings in the actual Sheriff's Department from sheriff's deputies. And we currently have 3 openings in the Corrections Division with no list, which the lists come from publicsafetytesting.com. And for your callers that keep wanting to tattletale on the sheriff, I can provide you all with case numbers out of the prosecutor's office, from the Washington State Patrol, from the sheriff's office, and from other people that seem to want to characterize me as a domestic violence assault person, which is the farthest thing from the truth. Your caller was arrested by me for hindering and obstructing and trespassing on the county buildings, which was, I don't know, probably 3 years ago now. But I can also provide you that case number, not the status of the felony charges that occurred, but those are also available if you would like, and I could get you all the numbers.
Good morning, Commissioners. Thank you for this opportunity. I wanted to share with you something as a land developer that has really caught my attention over the last number of years. Here in the last couple of weeks, the City of Pasco approved spending $180,000 out at the processed water reuse facility that they just presented to you earlier. And what that $180,000 for is for habitat exchange. So what they're doing, in my belief, this is a new tax that the bureaucrats primarily, and they do it with lots of different ways of doing it. They use RCWs and they use municipal codes and different things to do this. But what it is it's an exchange. And what they do is it's a 2-for-1 exchange rate, where that they say you're hindering critical habitat and you now need to pay for the value of that in a 2-for-1 exchange rate. So the City of Pasco just approved spending $180,000 to exchange this critical habitat. And so they will pay that money to, in this case, the Department of Fish and Wildlife, and then Fish and Wildlife will then go purchase land from somebody at who knows what rate, and it now becomes public lands. And this land that they're exchanging is no different than you would see in the corner of a circle out here in the county. It's not critical habitat, but we're spending taxpayers' dollars to buy land from taxpayers that now cannot be productive land. And I think it is very, very wrong. Just wanted you to be aware of that, just something to pay attention to. I'm seeing it happen in the development community out at the Broadmoor area that they're in the process of doing. My understanding is on that one that the man that owns that land is going to have to buy or pay for 400 acres worth of exchange habitat to exchange for that. We have provided so much habitat in the Columbia Basin Project with what we've done with the improvements that you can't measure it. And yet now here they come again to force us to then exchange further. So I'll be really, really quick on the promotion of Franklin County. I think that's a really good idea. Some ideas: promote Juniper Dunes, the hydroplane races, the trail along the Snake River up towards our state waterfall in a state park. fishing and recreational uses of the river. And then one last thing about the road permits. I'm really thankful you didn't take action on that today. I appreciate our county engineer and his job of protecting the roads. As somebody that has done cattle and worked in the ag industry for a long time, first off, when there's something of this significance that you bring that will impact the county and the ag farmers in our county, which is our #1 industry, I would appreciate, or I think that it would be wise to let the stakeholders have a say. And when I pull a truck off the road into a wheat field to load cattle that have been grazing on wheat stubble, what is the criteria that says what a temporary use is or how many times? I can tell you that there's ag industry that hundreds of times a year make egress in and off of the road at different times with different farm equipment, and definition of what temporary is, I think, would be helpful. Thank you.
Thank you. Mr. Davidson?
No, I just at the same time.
Yeah. Anybody else for public comment?
Kathy Sant, Franklin County. My comment is for the proposed Public Works fee schedule packet. I don't think it's the commissioner's position to tell anybody who they need to look at while they're speaking. I don't think that's against any rules or laws, especially in that kind of a manner. So usually I don't get looked at when I'm speaking except by Commissioner Mullen. So I just wanted to let you know that you need to have a permission to even for a yard sale, and it's totally inconvenient when you have to do that. And my son has a construction business, and even though he lives with me, if I want him to do work at my house in front of the road that I pay taxes on, we have to get a permit for him to be able to park his truck and trailer and construction equipment in front of my house. So I just don't think it's any kind of inconvenience for the farmers to have to pay if they use the roads. My son was building something out in the county. He had to get permits to take rocks over there and everything else. So I just feel like we have permits, and I wanted to know if this is a law that was spoken of earlier, if this is a law that we have in the state or in the county. And also, I don't know how people have time to come to a meeting to speak on this if they don't have time to go get a permit. So I would just like to make these comments and just say that I just think we need to follow the different rules. I pay for public roads, and the commissioners always say how important public roads are. But if we don't have fees to fix them, I don't know where that will be coming from. Thank you.
Thank you. Anybody else for public comment? Nobody on the phone?
Nobody on the phone?
So with that, I think we're going to go into a closed session. Is that correct, Mr.
Yes.
Davidson?
First, we have a closed session pursuant to RCW 423140, Section 4, about contract negotiations, to get an update on the contract negotiations from our HR director. I would imagine elected officials would be, okay, it is. And duration, this is going to be rather short, right? 10 minutes.
like to open the door, we'll come out of closed session. We are out of closed session and back to regular session. And Mr. Davidson, I think we need an executive session.
So now that we're back into regular session, I think we're wanting to
Make a
entertain the
motion.
Resolution 2023-035, non-bargaining COLA adjustment.
Move for approval of Resolution 2023-035 as presented.
Second.
There's been a motion and a second for Resolution 2023-035. Is there any discussion? Hearing none, all in favor say aye.
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 Aye. So with that, we got an executive session?
We had one executive session, I believe, Commissioner Peck, you've requested one, correct, for procedure of the application process?
Yeah, what is the nature of the exec session that you have in mind?
It's evaluate qualifications for applicant of employment. And,
I think they could probably be done at the same time.
okay, so if that case, executive session, I'm asking for executive session for about 15 minutes pursuant to RCW 423110, Section 1, subsection G, evaluate qualifications for an applicant for employment.
So at this So we've come out of executive session. We're going to recess back to executive session for another 10 minutes. We're out of executive session, going to extend for another 10 minutes, same RCW. There we go. All right, we've come out of executive session. We're back to regular session. Is there any other business for the good of the county?
Did we ever come to a consensus on who the representative would be for the opioid settlement?
Oh, no, you didn't bring that.
I
Yeah.
suggested Shirley, because she's up to date on all the meetings and everything, but I need to
Consensus?
consensus.
So, Jennifer, if I could just get your, I guess, concurrence on this, it is sort of the point person for collecting our proceeds under the opioid litigation settlement. And in the WASAC meetings, I've heard a wide variety of different people at counties being identified as essentially the point of contact. You have any advice or recommendations? You okay with Shirley out of the county administrator's office being that person?
Yeah, I've worked with her quite a bit on this issue, and she is up to date on everything
Okay.
and well-versed in it, so I think she'd be the appropriate person.
Great. I appreciate that. Thank you.
So we have consensus?
Yes.
Yes, we have consensus. So is there any other business for the good of the county? Hearing none, this meeting